across the board, and as is particularly prevalent for today, he advises clients with respect to sports rights and sports rights holders. So with that, it's my pleasure to introduce Andy Danson. And Andy, take it away.
Thank you very much, Mark. Very kind of you. And hello, everyone. Thank you for joining us today. I think as Mark was just saying, I've always had a practice which spans the betting and the sports sectors, and the areas where the two meet have always particularly fascinated me. And data rights is really right at the heart of that, and close to my own heart. So I'm particularly excited about the session today, and that is even more so given that in true IMGL style, we've got a stellar panel put together today. So first of all, we have got Adrian Ford, who's the General Manager of Football Data Co. For anyone involved in the UK data rights market, Adrian and Football Data Co. need no introduction at all. But I'm conscious that there will be a number of you listening in today who think that football is played with an oval ball rather than a spherical one. And so for those of you in particular, Football Data Co. represents the data rights of the English Premier League, the English Football League, the Scottish Premier League, Scottish Football Leagues, which by my reckoning, certainly my assumption, would make them the most valuable data rights in the UK and probably European sports betting markets. And Adrian, therefore, I suppose as general manager, has probably the biggest job on the sports side, at least in sports betting data rights in the UK. So Adrian, welcome. Great to have you here. We also have David Lampett, who's the Managing Director of Sports Partnerships at Sportradar. Now, David, I think Sportradar will be perhaps familiar to listeners on both sides of the Atlantic as one of only a handful of truly global leaders in the distribution of sports data rights to the betting and other markets. They have got official deals with the NFL, the NBA, the MLB and NHL, FIFA, amongst others. But one of the things that makes Sportradar particularly interesting for today's discussion is that they often distinguish themselves from some of their competitors by advocating against exclusive official data rights deals for one particular partner. So I'm sure we'll talk more about that later. And in his role, David is responsible for Sportradar's partnerships with the sports sector. Before that, he was CEO of Portsmouth Football Club and head of financial regulation at the FA. So hello, David. Great to have you with us.
Thank you, Andy.
And finally, we have Toby Bond. So Toby is a part of Bird & Bird's top-ranked IP team and has a particular specialism in database rights, certainly in the sports and betting sectors, but also in other sectors as well, which brings some interesting perspectives to the discussion. He has advised a number of major players in this sports betting sector, or whether that's on the betting side, the sports side, or indeed on the distributor and agency side. So hi, Toby. Great to have you with us as well. Thanks. So before I open it up to discussion, I thought I'd give us a quick run through of the agenda today. We're going to start off by talking about the legal background in relation to the protection of sports data rights. We will then move on to what I expect will be the main event, which will be a debate around and between official and unofficial data rights exploitation in this market. We will also touch on the relationship between sports data rights exploitation and sports integrity. And we will finish off with a little bit of crystal ball gazing and look to see what might be coming down the line in the future on both sides of the Atlantic. Before we plunge into that, I just thought I would take a couple of minutes to do a little bit of scene setting, because I think sports data rights have always been really crucial to the sports betting industry. It's very difficult, nigh on impossible, to run a successful sportsbook without reliable, accurate and fast sports data, and that's never been more the case than it is today with the prevalence of in-running and in-match betting. And sports data, therefore, really lies at the heart of what is clearly a very mutually beneficial, but also sometimes uneasy relationship between the sports and the betting sectors. And the issues that it throws up, I think, have always really been driven by commercial considerations and also intellectual property law, but also, as I mentioned earlier, have a real relevance when it comes to integrity issues as well. And these are issues that in the US over the last couple of years, regulators and legislators have been grappling with as well. And I think on that note, the timing of this webinar is not an accident. Clearly in the UK and Europe, where we've had regulated online sports betting for many, many years, I think we thought that the issues around legal protection of rights in sports data were settled many years ago. But actually, in the last couple of years, we've seen a real flurry of activity in the area. And I think, certainly speaking for Bird and Bird, I think it has probably been the one area where we've seen the biggest growth in new instructions on the sports and the betting side in this area, which is probably at least something of a bellwether for what is going on out there in the wider market. Why is this happening now? I certainly think that one of the key reasons was the repeal of PASPA a couple of years ago. I think the opening up of the US market has focused a lot of minds. Certainly the revenues and potential revenues from the US. We've seen something of a state-by-state rehashing of the arguments that we've historically had in Europe, and some new arguments as well. I think one of the interesting developments we've seen is some legislators and regulators in the US enshrining the use of official data rights in regulation, which I guess perhaps we shouldn't be surprised about, because the intellectual property protection of sports data available in the US is not quite so comprehensive as it is in the UK and Europe. It seems that the prices of sports data are going up, and at the same time, as you'd expect, the enforcement around official rights is increasing. And I think as a result of that, we're also seeing more litigation in the area. In just about 3 weeks' time, we're going to have the Court of Appeal hearing in what is a fascinating case between the Racing Partnership and SIS in the UK, which is about the protection of rights in sports data, not through intellectual property rights, as we've historically seen, but through the laws of confidentiality. And I'm sure Toby will touch on that in a moment. We've also got a competition law complaint that I must mention being brought by Sport Radar against BetGenius and Football Data Co. Particularly relevant given today's panelists, where Sport Radar are arguing that it would be anti-competitive to restrict access to sports matches to only one official data provider. So what does all this mean for the betting industry? Clearly, as consumers and users of both official and unofficial sports data, I think it's really important for the industry to be aware of the changing legal and risk landscape in this area, not least because betting operators can be and historically have been joined to legal action where they use unofficial data that's potentially infringing. Now that is, I think, quite enough of me and the introduction for the time being. So I will hand over to Toby, who's going to talk to us a little bit about the legal background, which I think is the right place to start, because I think that legal background really underpins some of the commercial and the policy considerations that we'll be talking about in a moment. So Toby, over to you.
Great, thanks very much, Andy. So good morning, everyone in the US. So I think, as Andy mentioned, the law was reasonably settled for a while. We had a flurry of activity of sports data cases in the 2000 and early 2010s, but we didn't really have a large sports data rated piece of litigation in Europe until last year when we had the TRP and SIS decision, which I'll come back to at the end. The starting point for the sort of legal framework in which we think about sports data rights in Europe is actually a negative. When it comes to information and facts per se, they're generally, at least in the UK and in pretty much every European jurisdiction that I'm aware of, information and facts per se are not considered a form of property. You can't own a fact. But of course, we do have a variety of legal protections which can apply to data and to databases in the sports context, depending on the particular circumstances. And those are copyright, database rights, and also confidential information protection. It's worth noting as well, we also have contractual rights that can be imposed around data, and often those work together with the underlying IP or rights of confidence. We can also potentially have contractual rights separately. So in the UK, the courts have held that it is possible to license data even where there's no underlying intellectual property rights in that data. But the key benefit of having an intellectual property right in your data is you can enforce those IP rights against third parties. Whereas compared to contractual rights, you can only enforce a contractual right against a counterparty to the contract. So having an IP right really gives you a strong position as a licensor of sports data. Now, just a quick note on we're talking about European law here, but there obviously are different legal systems in different European jurisdictions. Database rights are generally quite harmonized. There's a single piece of legislation from which national laws will derive, but there are some differences in the national implementation of that legislation. Copyright has traditionally been less harmonized at a European level, but that has changed over time. The European Court of Justice has put in its best efforts to try and harmonize things. And we've also seen more legislation coming through on the copyright front, which is bringing more harmonization. Now, when it comes to confidentiality, historically, this has been the most divergent area, but we did see a couple of years ago, we had the Trade Secrets Directive introduced and implemented at an EU level, which does give a minimum level of protection for trade secrets. So we're now seeing a trend towards greater harmonization of the rights which are relevant to sports data, but there are still differences. Now, applying rights in sports data applying those rights to sports data, generally we think about two categories. We firstly think about pre-match or pre-race data. Generally, this type of data isn't going to be confidential because it's going to need to be published at some point. You need to make people aware about the details of the fixture or the match. So confidentiality doesn't really help us here. One of the biggest cases we had in sports data law related to the application of database rights to pre-match or pre-race data. When we had in 2004, we had the Court of Justice saying the BHP and William Hill case and the fixtures marketing cases that investment in compiling race information and football fixtures wasn't sufficient investment to obtain a EU database right in that pre-race information database. Now, what we've seen in response to that BHP decision is that data licensing businesses tried to structure themselves so they separate out the data generating entities from the data licensing entities, and that gives them the argument that there has been investment in obtaining data, which is a relevant type of investment. So they do say that there are intellectual property and in particular database rights now in that pre-race or pre-match data. Now, to finish off the picture, we also have copyright, but generally this has been quite hard to apply to pre-match or pre-race data. Our individual elements of data, so the name of players, the name of horses, that sort of thing, that's unlikely to qualify for copyright protection as an individual piece of information because that's not really an intellectual creation of an author, which is what we need when we're talking about copyright. We can, of course, have copyright in compilations or databases in Europe if the process of selecting or arranging the contents of that database or that compilation is an intellectual creation. But the stumbling block we came across in the sports data context was in 2012, we had the Football Data Co. and Yahoo decision when the CJEU said that fixtures lists were not protected by copyright because they were dictated by technical constraints and there wasn't enough room for an author's intellectual creation in those fixtures lists. So copyright for pre-race data can be tricky. Moving on then to live sports data. Well, of course, we have copyright in broadcast of events. This is a classic thing that copyright will cover. But but generally where copyright won't extend to the individual pieces of data generated by those events. So the fact that someone scored a goal, that individual fact or a simple record of that fact won't be protected by copyright. We do, however, have the possibility of database rights, and actually this is the key right when it comes to live sports data, because the UK courts, and I think the European courts as well, have confirmed in the Football Data Co and Sport Radar case that independent investment in recording and aggregating data generated by sporting events can be a sufficient investment for those databases to qualify for a database right. And this gives the official licensors of sports data a really powerful right, because those database rights can be enforced not just against their licensees, but also anyone who's taking data which derives from the official source and the official stream. So one thing it's really helpful in preventing in the online environment is if a licensee puts the data on their website, you can go after someone scraping the data from that website because they're still extracting data in which you as the official licensor have a database right. Now the third right, which has become more interesting recently, and this is what came up in the TRP and CIS case last year. Decision came down last May from our first instance courts in the UK, and there's an appeal of that decision due to be heard at the start of July. Now the issue in that case was about, are there ways to get unofficial data out of, in this case, racetracks or horse racing tracks? And the issue was that the organisers of the races had imposed contractual conditions on pretty much everyone who attended the event. So attendees via terms and conditions and all the commercial partners attending the race course, which prevented them and imposed obligations on them not to report live data from the events. Now there was one hole in this protection, and this was the tote betting organisation, who were on the race course but weren't subject to contractual restrictions. And the question came up is, had the race organisers done enough to make the live race data in the period after it was generated but before it was released by the official data feeds, was that information confidential because they put enough effort into preventing it being disseminated by people on the race course? Now the decision which came down last year was actually, yes, they had done enough to make that information confidential in the hands of the tote and also in the hands of CIS, who received the information from the tote. So CIS, by publishing that information they received from the tote, was acting in breach of confidence and was liable for damages and an injunction to stop them doing it. Now, the way the court did this was actually by applying an analogy with some case law from about 15 years ago to do with photographs taken at the wedding of Michael Douglas and Catherine Zeta-Jones, which had said that actually because the Zeta-Joneses had invested in making their photos of their wedding exclusive to a particular magazine, the court was willing to offer them protection. Now, what that does in the sports context is gives organisers of events potentially quite a powerful right to plug gaps in information leaking from their events. And I think there'll be great interest in people in what happens during the appeal and whether that decision, there is a right of confidence in live sporting data, will be upheld or whether that will be overturned on appeal. Now, just to finish the picture of the other hot topics in the moment, at least in European, in particular UK sports data law, Brexit and database rights is a topic which is causing some people headaches. In order to qualify for a database right, you have to have some connection with the European Economic Area. The UK has decided it no longer wants to be a part of the EEA or the EU. So from the UK's departure at the end of this year, potentially, if you're based in the UK, you will no longer obtain database rights in Europe. And if you're based in Europe, you'll no longer obtain database rights in the UK. Now, there are possibly ways to work around that with corporate structures and different arrangements, but it is causing some people some challenges. And I guess the final point is the one that Andy mentioned. There is interest at the moment about whether it's possible to compel access to data sources from official licensors. And I think that's probably enough of me for the legal background. So I'll hand back to you, Andy, to get the discussion going.
Thanks a lot, Toby. Before we go on to onto the big debate, David, perhaps you could give us a bit of perspective on how you see the protection of sports data evolving and differing in the US versus what we have in the UK and Europe, as Toby's described.
Yes, certainly, Andy, and thanks for the intro. We'll maybe come back to a couple of the points that Toby raised, because I think there are some interesting facets in the in the recent case law, and in particular in the TRP and SIS case around confidence, which are worth exploring a bit. I don't profess, by the way, to be an expert in the US legal position on data rights. As Toby has pointed out, the EU database directive, which affords additional protection in the UK and the EU, or the UK currently, at least until the end of the year, doesn't exist in the US, and therefore the kind of the legal framework in the US is different. But I think I would, without pretending to go into a legal analysis here, I would maybe take a step back and think of it in terms of how this market is evolving, and ultimately, as has been described over the last 10, 20 years, I think sports organizations have generally sought to find, because of the fundamental principle that Toby started off with, which is that the data in itself doesn't have an attached IP right. So, the facts and the information don't have an IP right attached to them directly themselves, a sui generis right, as we would describe it in legal terms. And so over the last 10, 20 years, we've seen with the increasing value that attaches to this data and information, particularly from a sports betting perspective, but also, of course, in media and other parts of our business, sports organizations have looked for ways in which they can get involved in and derive value from that part of the industry, from that value chain, effectively, to derive benefit. And I think what Toby has described actually is quite, I guess, a reasonably complex set of different pieces of the law that at different times, sports organisers have tried to utilise, and actually often unsuccessfully utilise, to try to create a level of control over the monetization of their data. And that's a real challenge, and we fully understand that challenge. And I think that challenge is equally being seen and being faced down in the US, where, there are some other kind of legal precedents with, Motorola's case with the NBA and the hot news, the hot news angle on that, PGA Tour and Morris Communications. So there are other legal precedents that, again, generally have made it quite difficult for sports organizers to clamp control around how their data is used. And as Toby said, very different to the way in which their audiovisual content, their video content is controlled, because, as alluded to, it is in that area, there is generally a copyrightable product, which, enables them to, and it's established globally, and therefore it's a kind of a more mature market. And that of course is what makes the data topic and these discussions interesting, because there is, there's more gray area involved. And I think what we've seen in the US over the last 2 years is, since the repeal of PASPA, is various efforts to, again, try to find either a legal framework, or in fact in the US as well, a regulatory framework which provides that protection directly to the sports organizations in relation to their data. And of I think the 24 states where there is now a legal framework for sports betting to take place, and that, that number is going up all the time. I think we expect it to be 27 by the end of this year, 30 or 30 plus by the end of next year. But across those 24 states, of course, one of the things that the sports have been trying to achieve is a mandated position for the use of official data, i.e., again, rather than creating a legal framework in contractual rights or IP rights, which is, as we've just heard from Toby, quite difficult, try to create a legislative right through regulation for that protection. And again, that has been, I would say, a mixed bag in terms of success, because at the moment there are only 4 of those states that have indicated, I think only 1 live, which is Illinois, and then 3 others in Michigan, Michigan, Virginia, and Tennessee, where there has been at least in terms of the way in which the legislation is being drafted. It hasn't necessarily yet come into force, but an indication that there will be a mandate or some sort of requirement to use official data in the sports betting sectors in those states. So actually, 3 or 4 out of 24 so far, I think again indicates the challenges that sports organisations face in trying to get to this position of having protected content. And from our perspective, as a sports data and video content business, that's really a double-edged sword, because on the one hand, we obviously operate and do business with the sports organizations. We want to continue to do that. We invest more than anyone into official data deals around the world with some of the major partners that you mentioned at the top of the webinar, Andy. But of course, we also serve multiple downstream markets, and I think the position that we adopt ultimately is that we want to see that market evolve in a way which protects healthy competition, that protects innovation, that protects fair pricing, and that creates a healthy balance between, on the one hand, the interests of the sports and the sports organizations, and on the other hand, the interests of the downstream market to have choice, to have product choice in making their business decisions as well. And so I think those are some of the challenges that we face. Sometimes, as said, being an intermediary between those two different sides of the coin.
And thanks very much, David. And I think that your closing sentiments there are probably the perfect lead in to the main part, what I think will be the main part of the discussion today, which is about this discussion between official and unofficial data, whether there is a place in the market for unofficial data, or if not unofficial data, then a plurality of official data. And I think the best place for us to start off here would certainly be Adrian to please give us your views on the importance of official rights, the importance of an ability to impose exclusivity, and what that means to sports businesses.
Good afternoon, everybody. Thanks, Andy. And good to hear that sport's giving lawyers something to do. That's going to make my day. I'm sure everyone else listening to this call. So yes, we're a sport. I think just going back to the last conversation just quickly, the one thing that is similar between the UK and the US is that there is no framework that governs what should happen between sports and betting. And that's just a fact. And I think what US sports have been trying to do is establish that position if they possibly can. And certainly from my point of view, I can completely understand that. What we have got, as you have expanded on, is some IP, and therefore we've been able to use that as a way of trying to create a framework to have a commercial relationship with the betting market. And that's the one big difference I think that we've got at the moment. So that's as much as you're going to get from me on legal matters. From a sport point of view, if you go back to the start of Datacode, 2001, I wasn't there. I had hair then and was younger and more handsome, I'm sure. But the idea was data could become quite important, and it could have a commercial value, and we need to try and figure out how we manage it. And that's why Football Data Code was formed. But it's not just about commercial. I think the key point was that sport, and our sport in particular, needs data to help tell stories. It's not just about pound notes. It's about a commodity that has a value as part of the whole editorial process. So from a data code point of view, it's not just about the betting market, actually. And whilst that might actually be the most commercially lucrative for a data owner, actually that's only one part of it. And so when data code was formed, it thought, well, this data could become really important. So if it is, then we need to be able to have some control here. And I think they were very prescient when we look back to 2001, because clearly that's exactly what's happened. And so I think from a data code point of view, data means some commercial value, absolutely, but it's about trying to have one official source of facts and of the truth that embodies and helps storytelling. because sport is fundamentally needs the right answers. And so I think where we start is data and unofficial data is you've got to have one source of truth, because you can't have different views about who scored a goal, who took the corner, who took the foul, because you're going to get yourself into all sorts of trouble. So I think that from our point of view, official data is about control and it's about one source of truth. And I think that is really important for sport in general, not just football, but any sport. If we then move it on to, and so it's important to say, perhaps certainly over to the American people listening in, we separate our data rights into two. We have media rights and we have betting rights. And yes, the betting rights are more valuable, but actually in some respects, the media rights are much more valuable in the context of the sport as a totality, because it's that data that supports everything else and adds value to the broadcasting. And that's obviously where the real money is. So I don't want to be totally myopic about this. It's not just about betting. It's a much wider debate than that. But what's common to both sides is that you want one official truth. You want one version, and that is what goes out there to the world, and there can be no doubt about what happened. I think that, therefore, from our point of view, when it comes to betting, and by the way, I would say from the sports point of view, sports have to make their own decision whether they want to recognise the betting industry or not. You know, and there are some sports for whom getting too close to the sun just isn't worth it. They don't want to do it because of the necessary issues around integrity. So each sport's going to have to make their own decision on that. But if you decide that actually you want control, and if you recognise that betting happens, really what you want is the same source of truth applied to the betting market as you're applying to your media market. And so for us, and I will shut up because we want this to be discursive, I think that is the fundamental basis upon which we look at rights. It's about having official data and one source of truth.
And thanks very much, Adrian. Can I invite? I don't think we need to bounce back and forth off me for permission to speak. So perhaps, but David, and Adrian, please feel free to chip in with your views.
Yes, certainly. Shall I take up the gauntlet then? In which case, Andy, and yeah, as you say, it's yeah, we'll try and get the discussion going. Yeah, listen, I know very well Adrian's position on the single source of truth. I guess the problem, as we described earlier, is that the legal position and the legal analysis, just doesn't support that. And if we flip that into the question that you originally asked on official data versus unofficial, or what we prefer to call open source data, it's very clear that is entirely legitimate. It's entirely legitimate that there are alternative sources of data, alternative means by which data can be collected, and we are not alone in that. So SportRadar's business is built on both, or our data business, because we are a wider organisation than that, but our data business is built on both official data and open source data. And by the way, that is true of every major global sports data business out there. That's not distinct to us. That's true of all of our competitors as well. So just as we may not have the official status with Adrian and with Football Data Co, as you alluded to, we do have that official status with the NBA or MLB or NFL in the US. And of course, our competitors are providing competing products for those, for those sports through data collected through public sources, publicly available sources, therefore providing that open source content. So when we're not alone in that, it's not that we're doing anything different to the market, in fact. And our position, I guess, is quite simply that there's nothing wrong with that. It's legitimate, as we've said. There's no there's no legal barrier to us being able to do that or anyone else being able to do that. And therefore, what the market really comes down to, and I think this is the real kind of point of challenge here, is that our view very clearly is that the extraction of value from this market should absolutely be driven by the quality of the product. And therefore, if the official product, because there is going to be, I think the word you used earlier, Andy, was plurality. But given that there is plurality of supply, then the value has to be driven by the quality of the product. And a provider of official data, if a sport chooses, and as Adrian said, some sports choose not to provide an official data source. The NFL is a good example of that, who until this season, or the season just passed, didn't have an official feed for their data for betting, but they did implement that for the season just gone, and we were very pleased to be their partner for that. But in some circumstances, sports don't do that. But where they do, if they, in order to create value from that product, it has to be driven by the quality of the product. It should not be driven by an exclusion of anyone else being able to provide, a competing service and a competing source. And I guess, the bit where I slightly part company with Adrian, in relation to the single source of truth, is that, generally speaking, it's just not an issue. I think many of our audience today will come from the sports betting industry, and as said, that industry has managed pretty successfully over the course of the last 20 years, 25, 30 years, particularly from an online betting perspective, before many sports, even conceived of the idea of there being an official feed or an official data source. And they've managed that pretty effectively because, generally speaking, in relation to many of the items of fact that we're talking about, there's not a kind of meaningful debate about what did or didn't happen. And so that the management of those outcomes actually is not really a significant risk for that downstream market. And so I said, for us, it comes back to, and that obviously drives our business decisions, is do we see there being a value creation opportunity in that official data product? And is that official data product going to, be strong enough in the downstream market to create that value? And that's, for me, that's the challenge for rights holders, is how do we make sure that our official product is the best in market? And that's really how it should be. The sport should be thinking about dragging custom and value to their product rather than seeking to foreclose anyone else from doing anything else or talking about single sources of truth. Just have the best source of truth and drive great value from it.
And I think let's just assume that there's not a fundamental problem with unofficial data. I think what you have to accept is that it's going to be inferior because it's going to be grabbed off of TV pictures, and it's going to therefore not necessarily capture everything that any particular customer needs. So at that point, you start saying, well, why wouldn't you want official data, which is better? And I think where the argument starts to unravel is that because the unofficial product will be inferior, if people haven't got the official rights, they might want to decide that they have to come into the stadium to get similar facilities that the official provider has. And I think that's where you get into problems. And I think this is the debate between unofficial and official, is they can't be comparable on the one hand, and the only way you can try and make them comparable is to breach ticket conditions to come in and do it under the stealth of darkness. And I think that's the problem that we have.
Thanks, Adrian. So, and I think it comes down to an interesting point where, David, you're saying open source data, as you call it, is entirely legitimate. I think, Adrian, I think your view on that differs depending on where that source is and how open it in fact is. I think that David, do you feel there is an entirely legitimate way of creating a data feed which is as good as an official data feed?
Well, I think that's a a fair challenge, and that's ultimately why why we and many others are prepared to pay for the kind of the privilege of having access on official data, and access to official data, because it can be a driver of value, because it can have significant advantages over the open source alternatives. I think 2 points perhaps on that. The first one is, I think one of the things that sports organizations are going to have to deal with or start to think about as this market matures and develops, is that perhaps partly an answer to Adrian's question as to kind of why would anyone want anything else other than the best product. Well, the reality is that there is not a homogeneous downstream market, and different businesses might make different decisions about different content depending on how valuable it is for them, and therefore in some sports they might want to pay a premium, or might be willing to pay a premium for the premium product, and in other sports which may be less valuable they may not. And I think one of the things that that sports haven't yet kind of grappled with through this process is how do we create more than one product in that downstream market that can drive value. At the moment they just take the view of there's one official premium product, and it's kind of that or nothing. And so I think that's an interesting challenge, and an interesting perhaps way in which we may see the market continue to develop over the years to come. And to address Adrian's last point about access to the grounds, I think that's a really, well, without wanting to cut across, we obviously, as you alluded to, are in potential legal disputes, so we have to take some care. But I think I do want to clarify one point there, which is that generally speaking, I don't think that's it's a necessary facet of unofficial data collection or open source data collection to be in the grounds. The particular problem from an FTC perspective, and for the data that Adrian monetizes through the Football Data Co business, is that there is no alternative source. So because of the blackout rules in UK football and the way in which football is distributed, over broadcast domestically and internationally, actually for the vast majority of the content that is covered by FDC, there is no other mechanism to collect that data unless you are present at the grounds, because there isn't as I said, there isn't an alternative source. Now, we had a legal case with FDC back in 2011-12, which I think Toby mentioned at the start, and the outcome of that case, in relation to the database right, was you cannot, and we as a business and as a responsible global business cannot put ourselves in a position where there is any question about the source of our data effectively. So we can't take any other public source unless we're kind of seeing the game live and collecting the data through our own efforts, and therefore creating our own database, because I think that's another critical point, is we as a data business want to be able to create our own databases. There shouldn't, and there's no reason why only one database can be built and controlled and owned by the sports organization itself. We build our own databases ourselves. But in order to do that and to invest in that creation and collection, we cannot rely, and it would be irresponsible of us to rely on any other public source. So in order to avoid infringing Adrian and FTC's database rights, actually the only way that we can then do it, and create a competitive product in that downstream market is to actually attend the grounds. And that I guess is a fundamental point that we will maybe end up thrashing out in a courtroom at some point. But I think it is it's an important distinction, because I said it's, and I think it's one of the things that really distinguishes FTC as a as a property and as a data asset, as against many of the other data properties that we talked about, from NFL to NBA to MLB, where or the NHL as well, where where those matches are all broadcast. Every match is broadcast and available, and that means that when we're looking at the investment that we make in those rights, we are already aware that our competitors will have access to create an alternative data product, an alternative data feed, competing in the market with us. And of course, what that also does is mean that we're in a position where that drives an element of competition, product choice, and therefore fair pricing in that downstream market for the ultimate end users.
I mean, I think that I would just ask two more questions, but it seems remarkably like the downstream market is trying to tell sports what it wants, because that's the way that it wants to make its money. And I think sports always got a problem with people telling it what it wants to do if it doesn't fit sports' own agenda. So that there is a bit of an issue there. And I think this is a classic case of this, where we're being told the right way to do it because that's what suits everybody else. And no sport likes that. And I think what really makes it more difficult, if you buy in any way my argument that there should be one source of truth for consumer protection, for integrity, for lots of other reasons, is that the data that we provide is available to be sub-licensed. It's not like it is exclusive in the point that no one else can get hold of it. And I think from our point of view, we get frustrated when people in the value chain, because of competitive rivalries, don't take pretty simple decisions when they are there and effectively everyone can win.
How many? I would only ask Adrian how many people have taken a sub-license, Andy, if I were moderating this panel.
I've talked about the value chain. I think it's a problem with the value chain. And it goes back to my first point that the value chain is trying to tell sport how to do it. Sport's got a number of ways in which it can do it. It has no power over betting operators really, apart from the fact you can't take a bet without data. So I don't think it's wrong to try and set a commercial strategy that creates a return, but at the same time tries to protect integrity and provide some level of consumer protection. And that, as I see it, is our goal. And actually, I see it as exactly the same goal from people I speak to in the States. And that, they don't even know IP protection that they can fall back on. That's why they've taken the route they have. And you debate whether it's been successful, unsuccessful, wise or otherwise. But the point is, they had nothing. We at least established our IP right. We have something. But the reality is, there is nothing that regulates the relationship between sport and betting, particularly when it comes to commercial factors. And we're the ones who will be left holding the baby in certain cases, notwithstanding the fact that I know that betting operators do not want to get involved in kind of match fixing because they're the ones who also hold the baby. But the reality is, it's about sport, and there is no betting without sport, and there is no betting without data. There's got to be a better way, and I don't think sport should have to recalibrate what it does just to satisfy the middlemen in the value chain. It doesn't work like that.
Well, I think that's I think that's a fine position to adopt, as long as it's obviously as long as it's done within the bounds of the legal requirements, the legal framework, and that's obviously what we will maybe one day thresh out, and we can have another seminar or another webinar just like this on the outcome of that action. I think the point, Andy, perhaps that we can follow up on though is the integrity point, because I think that is a key one, and I know that's something you wanted to address.
Exactly, and that is in fact what I was just about to say. So I mean, Adrian, you've touched on the integrity point there. I'm interested, Adrian, in your views, first of all, on the relative merits from an integrity point of view of having one official data source versus multiple data sources, and how best to protect the integrity of sport from your perspective.
It's a really difficult one, this, because I think it's easy to talk about the philosophy. And I think anyone would agree that if there's one data source, the risk of data being somehow manipulated, changed, or somehow used to create a scenario which was effectively going to have a fraudulent outcome, that must be obvious. the reality is that there isn't too many examples of where it actually happens, and that's where the argument becomes heated. But I think the idea that says you have one data source, it's the official truth, it's collected on behalf of the rights holder, probably in Stadia, got various checks and balances, and that's the data source that people uses, that must restrict any potential risk for integrity faults. So that's the first point. I think there's also the issue about consumer protection. Again, if you've got varying sources, particularly in the betting market, depending where you're betting in the world, you have no guarantee that that unofficial source is going to be anywhere near the true source, and therefore you are open to potential bad practice. And just to illustrate that point, I did this literally before we came on here. I had a look at 3 bookmaker websites. And when you look at disputes about whether a fact is right or wrong, normally, and I've done this for the whole global betting market, normally they will point people back to the website of the official governing body or the official data provider, in this case, EPTA. And I think that's what's telling you, is that having one source of truth, it being related to the rights holder, is the most effective way to get the right outcome for consumers. And from our point of view, it's the most effective outcome to try and protect against integrity abuses.
David,
shall I step in?
agree?
Shall I step in? Because I think there are a couple of points to make in response to that. And you will find no greater proponent of supporting the integrity of sports competitions and doing whatever needs to be done to protect the integrity of sports competitions than myself or than Sport Radar. It's in our DNA. We've developed the world-leading system to monitor and safeguard the integrity of the world's betting markets through technology, over the last 15 years, and have been involved in numerous cases, both through sports disciplinary as well as through the criminal courts to bring those perpetrators to justice. And I think that's, I think that therefore one of the challenges to Adrian's position is simply that there is no factual basis, there's no evidential basis that he can bring that suggests that open source data, unofficial data, gives rise to any greater integrity risk than official data. Now, like that, it just doesn't. There's no factual basis for suggesting that. And actually, as I think he kind of preempted and alluded to, the fact that at certain levels, and I would make a distinction here between the top level sport, which actually Adrian is generally dealing with, and lower level sports. But at lower level sports, certainly having a single source of information actually creates a negative risk. It creates a risk rather than resolves a risk, because actually having multiple sources and from a validation perspective, as much as anything else, is healthy for the market. It's healthy for us in our business, and it's healthy for others. And we've seen through this recent crisis some of the risks that attach to that. We've seen ghost games of football in Ukraine, actually from Adrian's principal provider, where for those who don't know, ghost games are where actually events are created. Events are created for the purpose of creating a betting feed, but actually the event doesn't even exist or happen. And therefore is reported on and enables, as said, enables fixing and corruption to enter the sports betting system. And neither we nor bookmakers, and certainly not sports organisers, nobody wants to see those things happen. But they are risks, and they're real, they're real and present dangers in our environment. And I said it's one of the reasons why actually there is a case for multiplicity of supply, for plurality of supply, as you alluded to at the start, Andy. But I'm also realistic, and to maybe slightly align with Adrian's point, I'm also realistic that at the top level of sport, that risk is perhaps slightly less because of the level of scrutiny over those sporting events. They're broadcast, they're watched by many people, so there isn't that same specific risk of ghost matches doesn't exist. But for us, then, it just, as I said, it simply comes back to actually creating a healthy and balanced environment in which fair competition can flourish and drive innovation, and ultimately drive greater value for the sports in the long run if they play their cards right.
Okay, thanks very much, General. I'm very conscious of the time. I think if and I'm also conscious we've had at least one question. Before we move on to that, perhaps we could move on to a little bit of crystal ball gazing. If I could ask each of you if you had one prediction of the way that the sports data rights market was going to evolve, whether that's a legal or a commercial point, what would it be? David, let's start off with you.
Is this the way I think it will go, or the way I would like it to go? Yeah, listen, I will.
What do you think it will go? I think we know the way you would like it to go.
Yeah, listen, I think you know, my honest view is that, of course, there is continued and growing value to be driven in this marketplace. You know, not just as Adrian said, not just through the betting industry, but through the media industry, through sports consumption generally. And I think we are all, you know, as sports fans, we are all kind of increasingly data driven, and we want more and more access to more and more information, you know, that drive the narratives around how we understand the sports that we're fans of. So I think that, you know, that value opportunity will continue to grow. And I think that's also why, by the way, it is, you know, there are these contentious issues that will continue to crop up because, as we said at the start, there are grey areas. And I think those grey areas, you know, my prediction actually is that those grey areas will you know, probably still perpetuate for a while. I don't think they're all about to be ironed out. And as I said, my hope certainly is that we arrive at a balanced position. You know, my hope is not like of a kind of particular outcome in kind of from a legal perspective, but just that we arrive at a balanced position, actually really that avoids the need for any legal, you know, interventions in this particular area. And as I said, that results in, you know, fair outcomes for the bookmaking market, where they have product choice and supplier choice and, you know, creativity from the people who are supplying them with data. And it also means that the sports are able to generate and derive really healthy returns for their businesses as well. And I'd like to think that that's possible, Andy.
Adrian, do you think that's possible? And do you think it's going to happen?
I wasn't listening to that. For me, I think it's about official data will become more valuable. And as the market consolidates, particularly in the wake of where we are now, and I think the market will, the bigger operators will want official data because it will be the best. They don't want to take the risk. And I think actually as the market matures, and the market is immature, as David said earlier, that's what will happen. And official data actually will grow and people will accept it's the right thing to do. The problem we're all going to have is the offshore market. It's the pariahs out there. And our job must be to make their lives as difficult as possible so they have inferior products and they can't compete with the big operators, particularly as in-running betting grows. So I think official data has got a healthy future. And I think we have sports and betting operators who are responsible. We've all got the responsibility to try and squeeze out the unofficial market, because that's the problem for all of us.
Thanks very much, Adrian. Toby, do you have a prediction for us?
I guess a prediction would be, obviously the sports data market is a well-evolved data market and has generated a lot of the legal case law around rights in data, but the rest of the world is very much catching up, and sort of rights in data is a massive focus at the moment for a lot of legislators. The European Commission published a European data strategy earlier this year. They're looking very carefully at the legal rights in data from a sort of macro picture. They're talking about potentially adjusting some of the underlying IP rights. They don't have sports data in mind, but some of those types of tweaks to legislation around data could have a knock-on effect in the sports data context, potentially unintended. So if people want to track that and stay aware of it, if there are things that can affect you negatively or positively, then it's good to be aware of those. Definitely. So I'd say the world is changing and catching up, I would say, with where sports are.
And thanks very much, Toby. And I think for my part, I think we might see a combination of some of those issues that we've talked about. I think there will be increasing value sought, and I think there will be increasing enforcement around official rights, and there may even be increasing protection. But I think what that is likely to drive is more innovation in the data market. So I think we're going to see some very interesting developments coming up soon. Mark has joined us, our president, which is very much a tap on the shoulder to me and to us. I'm very conscious of the time here. We've had 2 questions from the audience. Mark, I don't know whether you want to pick those up or whether you'd like to wrap us up there.
Andy, why don't you take a couple moments and quickly address those questions, because I did see them pop through.
Sure. Okay. So, Adrian, I don't know if you and David can see the questions. I think if Adrian, we address the first one to you from Kim Alcantara, where there's only one official data, how do providers demonstrate that they're offering fair pricing? There seem to be some competition law issues arising which don't seem to be addressed. Are those suppliers required to offer them under auction to the highest bidder? That doesn't seem to be the case a lot of the time.
From my point of view, I think the way we look at it is that the value of this is in the license. Clearly, we separate the supply side from the license side. The supply side is where we see the competition in the downstream market, with all the aggregators doing clever things with data. And effectively what we're looking for is a license for the actual use of that our proprietary data. And I think that it's a fair point, and it's a comment that gets raised regularly. The reality is, I don't think it's in anyone's interest to price someone out of the market, because it will end up in the courts. And certainly from our point of view, there are standard licenses. Sorry, I say from ours, BetGenius do this in the market. I don't do it anymore. Effectively, there are standard licenses. It's effectively a rate card, and therefore it's transparent. And from that point of view, that is the best way to manage this, that it's done through agreement and it's fair. But I accept that it's quite difficult to set that down in this, this world where there is no regulated or no authorised relationship between sport and betting. And so there it comes down to common sense and commercial negotiation for me.
Thanks, Adrian. David, I think I will address the other question from Joel Goldlist to you. What if the official data does not cover all the specific data that a consumer wants to have before making a betting decision?
Yeah, and I think that, you know, I mean, from my perspective, that's probably more a question for Adrian as the, you know,
I can pick it up if you want.
as the man behind the official data. But I think it highlights, you know, it highlights one of the challenges with with not allowing or restricting or foreclosing that product choice and consumer choice in the downstream market. That it restricts innovation, it restricts people from being able to offer those different different potential avenues to create data around sporting events. And as I said, that's one of the things that is consistent as the the earlier question was with with our position and our concerns in relation to preserving that competition and that product choice in the market.
Thanks, David. So, Adrian, do you want 30 seconds just on?
Just quickly. I think it's important to differentiate between fast data, which is what BetGenius do, and that's very much supporting in running markets, and that's a lighter weight data feed, and it's covering most events. However, the prop bet style market, which I think this is probably geared at, Opta is our official provider. They supply data to betting operators, and I've yet to find a data field that Opta does not analyse through its very, very detailed feeds. So I'd be surprised if there were markets, but ultimately if that happened, then effectively that's down to the betting operator. If they've got a particular idea, there's no data, that's theirs to find and to basically take the risk on.
Thanks very much. Well, I think it only remains for me, and I certainly only have time to say thank you very much to David and Adrian and Toby. Thank you very much to everyone for listening, and back to Mark.
Andy, thanks so much. Really appreciate your all's panel. Fascinating information. Learned quite a bit out of it, and I'm hopeful that all our other participants and observers will enjoy this also. My thanks to Andy for putting the panel together. Our next panel will be July 2nd. Catherine Paisley, who is the General Counsel of Exacta Systems, will be talking about the creation and the growth of historic horse racing. Look forward to joining everyone on that. If you have questions, please take a look at imgl.org. That's imgl.org. And if you'd like to participate in the future, either as a panelist or have a concept that you'd like to see presented, please email our executive director, Brienne Van Dyke at brienne@imgl.org. Again, our thanks, and we look forward to seeing you again soon on behalf of the IMGL. Have a great day.